cooperative agreement has now been reached. So glad to answer any questions.
Thank you, Professor. Could you elaborate a little bit more on the role of the supremacy clause here and how that might affect? We've got some proposals before us today that we'll be talking about for changes in state law. And I understand there's some flux constitutionally right now within the federal courts about where the supremacy clause applies and where it doesn't.
So the supremacy clause is essentially is a constitutional provision which says that all federal law preempts all conflicting state laws. Like it's quite clear that the federal law has complete authority to decide who is admitted, who stays in, and who's expelled from the United States. So there can't be a state or a local law which is in conflict with that. Like the state of Minnesota cannot on its own decide how many people or what kind of people should be admitted to the country or to Minnesota. The state of Minnesota cannot dictate as to who and on what terms should someone be expelled from the United States. They have clearly earmarked for federal jurisdiction. Like states cannot on its own make working for an unauthorized person to work a criminal offense. So these cases have gone to the Supreme Court. Last time the case went to the Supreme Court was this famous Arizona case on challenging SB 1070 Arizona law, where the Supreme Court clearly delineated that, look, there are some fundamental principles of an immigration enforcement which cannot be in contradiction to us, which the state law cannot contradict. But on the other hand, there is some space where state laws may operate even on immigration function. For example, the best example of that is that states can have their own laws with respect to licensing of immigrants for a particular occupation in a state. The federal law doesn't preempt that. So where there's space left by federal law for states to have some say, that's a valid space for the states to operate. But where there's a direct conflict, the supremacy clause, the federal law prevails.
Could you also say something about, is there a distinction there between federal law and, say, federal agency policies for how they are going to implement or enforce their laws?
Yeah, as we all know, federal laws are broad, and how they're implemented is then governed by federal regulations, or sometimes by operating instructions, even sometimes by memos, because they actually decide the minute ways in which that particular statutory provision is implemented. But again, those regulations and those operating instructions cannot be in violation of federal law, and more importantly, they cannot be in violation of our U.S. Constitution. So having said the importance of the supremacy clause, nothing is more supreme than the United States Constitution, as you so rightly pointed out in your own introduction today. So at the end of the day, all federal laws, all federal regulations, and all instructions and manuals issued have to pass the constitutional muster. And that's why in most of these cases of immigration enforcement that we have seen in the last year or so, why the Constitution has come to play in a much more oversized way than we have been used to in the past. Like you said, the writ of habeas corpus. The writ of habeas corpus obviously has been present in our system since our founding. But in the immigration context, it was rarely used because immigration lawyers just went to immigration courts to enforce the rights of their clients. But with the given rise of the enforcement in the last 1 year, habeas corpus, which is a constitutionally protected right, has now become the vehicle through which many of those fundamental rights which we otherwise safeguard have now to be enforced and implemented.
Thank you. Do any members of the committee have any questions that you'd like to ask Mr. Chief? Senator Westland.
Thank you, Mr. Chair, and thank you, Mr. Chishti, for being here today. We appreciate your testimony and sharing your expertise with us. So my understanding of the scope of authority for immigration enforcement is that in order to take someone into custody for a potential violation of our immigration laws, my understanding is that there has to be a judicial warrant to take them into custody. Is that correct?
Yes, it's absolutely correct. Yes, it's absolutely correct. They need a judicial warrant to arrest someone, and if they are entering a home or an office of any dwelling, they need the right to enter that place. They need a warrant to enter that place, because otherwise that would be a violation of the Fourth Amendment.
Senator Westland.
Mr. Chair and Mr. Chishti, so would it stand to reason also then that immigration enforcement agents would have no authority to take into custody someone who is lawfully in this country or someone who is a citizen of this country? Is that fair to say?
Mr. Chishti.
They definitely do not have any authority to arrest any citizen of the United States. If they have a reasonable basis to arrest someone, to pick someone who made their reasonable basis to be someone is here unlawfully, and then they may be able to bring that person into custody. But certainly to arrest that person, they would need a judicial warrant to do that.
Senator Westland.
Mr. Chair and Mr. Chishti, if someone has been taken into custody unlawfully and in violation of the Constitution, someone who is here lawfully, someone who is a citizen, what remedies currently exist for that person for their unlawful detainer by the federal government?
Mr. Chishti.
So that's a really good question. I mean, as probably many of you who are lawyers here, and some of you are obviously very close to lawyers, know that there was a long-standing precedent in our country, the case called Bivens case in 1972, I think, or early, don't quote me, in the early 70s, where if there was an unlawful infringement on constitutional rights or our civil rights by a federal law enforcement officer, there was cause of action. You could sue the federal government. Post 9/11, Supreme Court revisited that case in a case actually called Ziegler versus Abbasi, which significantly curtailed the ability of citizens to bring actions, or lawfully placed persons in the U.S. to bring actions against federal government officials. And I think that's why many states now, and I can assure you there is a trend now of this, states are now making it a state action for citizens of the state to bring actions against unlawful and civil rights violations against federal officials. So that's why these new sets of legislative proposals that are now multiplying in many states are basically a way to circumvent and around the curtailment of the Bivens provisions.
And
Mr.
Chair and Mr. Christie, for those states that have enacted such state actions, have any of those been successfully challenged in court by the federal government? Where do they stand now in terms of procedural posture for any potential challenges?
Mr. Chishti.
I think to the best of my knowledge, none of them have so far been challenged. So I suspect they will be, and then we'll see, our courts weigh in on that. But right now, they remain unchallenged.
And Mr. Chair and Mr. Chishti, so if it is unlawful to detain or hold someone who is a citizen of this country, someone who is a permanent resident and not suspected of any criminal activity or no reasonable suspicion, for those individuals who are unlawfully detained by federal immigration enforcement agents, would it also be unlawful for those agents to withhold papers of those individuals or their personal property once they are released?
Mr. Chishti.
Exactly, especially if there's a cost associated with that. If the person did not get his documentation that will let them show proof or authorization to work, that's a harm. So any cost associated with the action or the inaction of the federal agents would be subject for action. And I mean, just point out, there was actually, even in this administration, recently a very big settlement made in Long Island here in New York, where some people, and they were not even citizens, they were immigrants in the country who had been held in a jail long after their time for their sentencing of the state crime had lapsed, because they were holding people thinking that ICE will come and pick them up. ICE didn't come to pick them up, and then they were held there without beyond the period they should be held. And there was a multi-million-dollar suit settled. So many of these things have successfully resulted in settlements, exactly for that kind of civil rights violations.
And
Senator Westman.
Mr. Chair, and I will wrap up soon. Mr. Chair and Mr. Chishti, that raises another issue that I certainly am curious about. So if I understand what you just said, so for our local law enforcement agencies and for our jails and for our Department of Corrections, once an individual in one of our state facilities has served their sentence, our state agencies have no authority to hold them beyond that term, even if there's a detention order from immigration. Is that correct?
Mr.
Yeah, it's called a detainer. Yeah, there are two, I think, courts of appeals cases which have held that if you hold the detainers from ICE, in this case, are purely requests, that if you hold a person beyond their normal time for service, you could then be liable for actions which may lead to punitive damages.
Thank you. Thank you, Mr. Chair. I think it's very important as we are having this conversation that we have an honest conversation about what has been happening in the state of Minnesota. And we have been told that there will be a drawdown. I understand that Mr. Holman made additional statements today that the final drawdown is going to happen in the next week. But I do not want anyone to think that because this has fallen off news stories that is receiving less attention, that there is that somehow less of the offensive activity is taking place, because we know our communities continue to be under attack. We know that people continue to be harassed. We know that they continue to show up in our hospitals. We know that they are showing up at our schools, and that they are not arresting the worst of the worst, that they are taking people into custody that they have no legal authority to take into custody. And so here in Minnesota, because we care about our neighbors and we care about our communities and we care about the rule of law and we care about the Constitution, we are making sure that there is going to be some accountability for the actions of a federal agency that has not been following the law, that has not been following the constitutional rights that are afforded to every person found in this country. And so I thank you, Mr. Chair, for having this hearing today. I thank the bill authors for bringing these bills, and I look forward to restoring lawfulness to our communities so that folks feel safe, leaving their homes, sending their children to their schools, going to medical appointments, and so forth. Thank you, Mr. Chair.
Any other members of the committee have any questions for Mr. Chishti? Senator Western.
Mr. Chair, to the testifier, if somebody comes into our country without the proper approval or paperwork, doesn't that give any officer of the federal government or state, if they're enforcing it, a legal right to detain them and hold them because they have broken the law?
Mr. Chishti.
So the broken the law is obviously, a complicated question. If someone, let just me clarify as to what are the elements of the unlawfulness here. If someone enters the country unlawfully at the border once, that is a crime, but it's a misdemeanor. If someone is deported and then re-enters, what we call re-entry without inspection, that's a felony. Those are criminal offenses. On the other hand, if someone is in the United States, has overstayed a visa, therefore is unlawfully present at that point, that's not a criminal offense, that's a civil offense. If someone is in the United States and unlawfully works, that means works without authorization, that's a civil offense. So there's obviously demarcation between whether there's a civil offense or whether there is a criminal offense. So if a law enforcement officer believes that someone has broken the law, they have to have a basis to determining that. I mean, how would you know that someone walking in the street has broken the law? I mean, you couldn't tell this from the face of the person or the accent of the person. And in this case, let me just sort of build on what I said earlier, that it's constitutionally protected, right? If you cannot hold a reasonable suspicion, probable cause, just on the basis of some of the appearance. And that there's been some confusion whether the Supreme Court recently has revisited. It hasn't. I mean, Justice Kavanaugh especially has repeatedly made clear that just an appearance or an accent or your clothing will not give you a basis to arrest someone. There has to be a legal basis to arrest someone. That means you may have a final order of removal, the judge has issued. Then that may give you a basis to arrest someone. But short of that, you cannot have you cannot arrest someone just because you have a suspicion that someone is here unlawfully.
Senator Westrom.
Thank you, Mr. Chair, and thank you. It goes to the underlying issue, though, if somebody is here illegally, there is a legal basis to hold them, detain them, or arrest them if once you've affirmed as you answered. Now, just on the face, I suppose nobody could tell other than if they've got pictures. That's what law enforcement does a lot, but they also may have a lot more information. Just as we're seeing in the Nancy Guthrie case, law enforcement has a lot of background information in figuring out who they're trying to find walking down the street or hiding in a residence or on a piece of property. So, but you answered my question. The legal basis would be there, and I'm just kind of adding to the last comments that said there's no legal basis to holding it that Senator Westland brought up, and wanted to just make that clarifying point.
But just to be clear on that, Senator, you're absolutely right that all the information would be available to an immigration officer, which the rest of them, that's exactly what they present to a judge. That, look, this is the basis of us to believe that this person is here in violation of the law, and that's how you get a judicial warrant.
Senator Kroon.
Thank you, Mr. Chair. To the testifier, I believe you said if state and local officials hold illegal immigrants beyond their normal time that they would otherwise be eligible for a release from prison or a jail based on an ICE detention order, I believe you said they could, and I think your word was could, be running afoul of the law. My question is isn't it possible for a state through an enactment of policy or statute, if the state wants to encourage cooperation so that they could make it easier to hold illegal immigrants and exchange that illegal immigrant to federal officials in a controlled environment rather than releasing them onto the street for future street enforcement? Could a state not do that and make it easier and legal for that exchange to take place in a controlled environment like a jail?
Mr. Chishti.
Yeah, I think that's a fair question. I think that's exactly where the degrees of cooperation between states and localities fall. I mean, this is sort of this classic debate about sanctuary jurisdiction. I've looked at sanctuary jurisdictions for quite some. There is no pure sanctuary jurisdiction in our country. I'm absolutely sure about that. No state or city says we will never hand over any immigrants who are in our jails. It's always about degrees of cooperation. And the degrees here, to me, means what level of criminality are you determining is the threshold for you to hold someone. And each state and locality, I think you're right, makes their own determinations. Like in New York City, for instance, there are about 130 criminal offenses for which the state will, or the city in this case, will actually cooperate with federal law enforcement officials to hand over their person. So it's the number of such crime or the degrees of criminality which determine the level of cooperation. And you're right, each jurisdiction on its own assessment of public safety determines for what categories of criminals is it important for them to cooperate with federal government and for which not. Classic example would be there's a murderer or a robber. Clearly we're going to hand over. But, making a wrong left turn in downtown Atlanta is a felony. So should we cooperate with the federal government on those kinds of, that's the kind of decision each locality and state makes dependent on its own assessment of public safety requirements.
Senator Cron.
Thank you, Mr. Chair, and thank you for that response. And I think that's an important point, that it is a determination for state lawmakers on how much we want to cooperate and where we want to cooperate. So it's not simply a fact of we're unable to cooperate and we're unable to hold illegal immigrants in a way where we can do this immigration enforcement in controlled environments. We can make that policy choice if we want to do that. If we want to reduce street level enforcement, we have a role to do where we can make that happen. Maybe not eliminate it, but we can reduce it. And so from my perspective, if we're going to be looking at state level policies, they should be opportunities for us to increase our level of cooperation with the federal government so that we can do a lot of this federal immigration enforcement that we've been seeing on the street. We can do that in controlled environments and reduce the street level enforcement. So, and we have a role to play in that, and I look forward to being part of that. Thank you.
So I have a follow-up on that, Mr. Chishti. What is the form or the lawful form of that request to hold someone beyond their ordinary release date in a state or local facility? Is it simple? Can it simply be a request? Hey, we'd like you to hold so-and-so until we can pick them up? Or does there have to be some kind of a warrant or a judicial action or some kind of a signed finding that would authorize that request?
I think it's literally, it's literally called the detainer. It's a request issued by ICE in this case to the local jurisdiction that we believe that the person who is in your jail or under your custody is in violation of the U.S. law, XYZ. And we want you to hold them, and we'll come and apprehend and arrest them. That I think, I can't tell you the form number that's called, but it is actually a physical form that is issued to the local jurisdiction.
And does there, Mr. Chishti, does there have to be any kind of a legal basis for that? Or can ICE simply submit the form? Are there any findings that they have to make? And what impact would those?
Yeah. So as we know by now, there's this, we had this provision of the law introduced during the Bush administration called the Secure Communities, which is what solidified a lot of this, is that anyone now who's taken into custody and gets fingerprinted, those fingerprints are sent, are matched against both the criminal database and the immigration database. And that is actually managed by a particular cell within the Department of Homeland Security. If the fingerprints match someone who is the agency has determined is in violation of the law, that then triggers the issuance of a detainer. So it's based on the file and the screening of the file within the agency that triggers the issuance of a detainer. So it's obviously based on something. It can't be based on nothing, but it's based on Department of Homeland Security's own investigation about the immigration history of that person.
And then there's a certain level of discretion, you're saying, on behalf of the local unit of government, or if the state were to make a state policy on that?
Yes, typically, and the detainers are not, again, there's a level of assessment of this. Detainers are not issued by even by ICE for everyone. They may not be interested, given their own resources, to shoot a detainer. If they decide the person of interest, then the local government decides whether to comply with the detainers or no. And it is generally held view now that detainers are just requests. They're not binding on the local jurisdiction. And whether they complied with or no, in response to other questions we just got, is determined by the local priorities of that particular jurisdiction. That there are certain classes of crimes for which will comply, certain classes of crimes which we will not. And that's sort of the negotiated, constant game going on between the federal and the state governments. And I suspect some of that happened with Mr. Home in northern Minnesota.
Right. Senator Uma Verbeten.
Thank you, Mr. Chair, and thank you, Mr. Chitsky, for being here today. One of my concerns is when federal agents break the law, particularly criminal law. And, you know, we have typically had our local law enforcement work alongside federal partners to conduct investigations into the killing of someone. There's a bill that our chair, Latz, will be hearing later on in this committee sort of regarding that. But can you speak to the authority that the state has to enforce its own laws, criminal laws, and sort of where the role that the federal government plays in investigating, you know, a federal agent, if there are any potential conflicts there, and where the supremacy clause would come into effect?
Mr. Chishti.
Thank you so much for the question. I'm really not an expert on joint investigations of particular crimes. I suspect that it's a classic case where states and local cops do what they are best equipped to do, and federal government brings its both investigative, it's data sharing, it's other means of investigation to bring to the table, which the state jurisdictions don't have, and they work cooperatively. What the degrees of that cooperation are, that what I suspect that it depends. My understanding is that soon. Initially, the case is decided what the lead agency is going to be, determined by where they think is it more a federal offense or more a state offense. Once you determine the lead agency, that lead agency determines the level of cooperation they would get from the other agency. But how that mechanics works, I'm really not an expert.
Mr. Chishti, can you say anything about what authority the state or a local jurisdiction would have to enforce their own criminal laws against a federal agent that may have violated those criminal laws?
I think it really depends on the state law, and I think that's why I think there is the resurgence of interest in the state laws about making federal officials hold them responsible. And I think most of this, let's just be fair about this, has happened because there was a statement issued by Secretary of Homeland Security, somewhat supported by the President's Deputy Chief of Staff, Mr. Miller, telling federal agencies that you have immunity. That sort of gave the signal that you're free to do what you should do in pursuit of a federal mandate. And that's really not true. It's just not true under our system of law and, under the constitutional protection. And I think that's why the states have now found it necessary, and there's multiple states on this, which have now decided to make their own statutory provisions to make it abundantly clear that you can sue federal agency. And part of it is to do with these recent statements by federal officials, but also, as I said earlier, about the perception that the right to sue federal employees has initially understood in the Bivens case law has been somewhat compromised. And I think this is a way to give rebirth to the old Bivens cases, and states are using whatever authority they have to do it.
And what about the rights of states to enforce their criminal laws against federal agents?
I think they have perfect right to impose their criminal laws. In fact, there was some speculation that one of the two federal agents who was involved in the shooting of Mr. Pretty was dispatched out of the state the very next day and transferred to Texas, which raised speculation among many lawyers that he would perhaps be subject to the criminal actions of the state, and you would now have to go through the difficult process of extradition from state. That, to us, just watching tea leaves, was indication that there was some concern in DHS that person could have been prosecuted under state law.
Senator Westrom.
Mr. Chair, to the professor, earlier you talked about the difference between coming into the country without any paperwork or approval being criminal, and if you're here on a visa and then you overstay it, it's a civil action. What is the difference between the penalties, or what agents can do to detain you, to the penalty and deport you? What's the difference between those two, if there is?
Mr. Chair.
Sure. There is, sorry, thank you. There is distinction. So if you enter the country unlawfully, that means without inspection is the formal term. You're committed a misdemeanor punishable for imprisonment up to 6 months. If you're a repeat violator, you have been deported once and you came again unlawfully without inspection, that's a felony punishable, I think, up to 2 years in prison. So if anyone is apprehended in the country, arrested on those two grounds, then you must be criminally charged and you must serve that sentence. At the end of that sentence, you could be removed from the country. Contrast that to the other example you made, that someone whose presence is unlawful. That means they entered country legally but then overstayed, or came legally but worked without authorization. Both of those are civil offenses. You can't bring a criminal charge against them. The only thing you can do is bring a removal proceeding against them on the basis of having violated a civil immigration law. So that's a civil proceeding. You can't jail that person. You can only have a proceeding started to remove them. That's the basic distinction.
And
Senator Westrom.
And Mr. Chair, during that proceeding of removing them for overstaying their visa, what do you do? Do you let them back out where you may not know where they are? Do you detain them until you have a swift hearing? Can you detain them for those days or weeks while the hearing is going on before you would deport them, assuming no other evidence come forward that
exactly. So, thank you. So when I was a real immigration lawyer, the first thing you did when you found someone's detained, you called a bond agency. That you would show up at the downtown immigration office where your client was being held, and you say, "I'm seeking a bond." And typically, the bond would just be issued by an agent administratively. Okay, $500 is. If the agency decides not to issue a bond, you would go to an immigration judge for a bond hearing. And that's where you had to have a bond agent willing to post a bond before you showed up at the immigration judge. So typically, in such cases, you got bonded out. And then you showed up for your master calendar hearing for the removal, and then you say, "I'm seeking defense, I have asylum claim." Then you will get a merits hearing. Till then, you will continue to be out on bond. What is significant in this Trump administration is that they decided not to grant any bonds. That will hold everyone. And in many cases, they issued directives that you must mandatorily detain someone. And that's what then led to this huge resurgence in the practice of habeas. because this administration realized that, yeah, you may have a lot of authority in immigration, but you can't override the Constitution. The Constitution still gives the right of habeas corpus. That's why all lawyers today, instead of rushing up to immigration judges for a bond hearing, believing they will not have a success there, go directly to a federal district court and ask for habeas. And that's what's sort of the nature of immigration practice has changed. And that's why, and all the reporting shows that the grant rates of habeas is almost 100%. That federal judges have found no basis to hold someone, but it's now deluging our federal district courts. They're doing habeas petitions all the time when they have more important decisions to take care of. Essentially, I think it's kind of, I think it's end round the bond hearings, but that's the price one has to pay for protecting the Constitution.
Senator Westrom.
Mr. Chair, Professor, so the bond hearings that you talk about, is that just been a practice or procedure and a choice? In the current administration has not used that bond hearing as you indicated, as it's been used in the past? Or where is it rooted in law that you have to use the bond hearing versus a temporary holding, if that's how I understood you correctly? Is it just a practice, or is it a constitutional provision that the courts have pointed to that says you have to have a bond to be released before you're deported during your hearing? I'm just trying to figure out, is that kind of your opinion and it's subject to another president or another department's interpretation or discretion, or where would that be rooted in the Constitution or the authority if the bond is the only way to use it, to detain a civil action of a person that's overstayed? Sorry, Mr. Chishti.
Thank you. As immigration proceedings are civil, so that's why there's a debate. Otherwise, right to be released is in the criminal context is different jurisprudence. In the civil context, which is what most of these things are, it's written in the regulation that you have the right to seek a bond. And the bond determinations are basically simple. Is this guy a flight risk or not? So the only decision, in fact, since I'm glad you're asking this question, since immigration proceedings are civil, the only reason to detain someone is to make sure that they show up for a hearing, because that's an administrative hearing. You just want to make sure he's going to show up, or he or she is going to show up. And to ascertain that, they are holding you, but to make sure that you also have a right to say that I'm not going to be a flight risk, I will show up for the hearing. You go before an immigration judge for a bond hearing. And the bond hearing is clearly has been our practice since immigration laws, were written into by Congress. And so the only decision that the immigration judge has to make is this guy a flight risk or not. And so the amount of the bond, all that is determined by that. And that's why I think when people are concerned about the look, if you really just want to make sure someone is hearing, there are alternatives to that. That instead, even if you don't want to have one, won't you just, give them a cell phone? We sort of are able to track people by very non-intrusive devices now. Many judges release people on these ankle bracelets. That's one way to monitor your shot. Now they are kind of, big, massive, little instruments on your legs, but they're now much easier, less intrusive methods of tracking someone. We call this alternatives to detention mechanisms. So there are more civilized ways of tracking some people. If you don't want to just bond them out on their own, that they will show up, which can effectuate the same purpose that you wanted this person to show up for a hearing.
Thank you, Mr. Chair. One last question, and then Professor, a little in that same vein, if somebody is here criminally broke into the country or came in illegally, as we distinguished before, they don't have the same constitutional rights as an American citizen that's been born here and is a U.S. citizen. Do they have any constitutional rights based on the courts? And then is there a distinction between somebody that's overstayed their visa and the constitutional rights they would have versus an American citizen, which my understanding is you wouldn't have the same constitutional rights if you're here illegally?
Mr. Chishti.
Oh, well, that's not true at all. I mean, luckily or unluckily, the Constitution applies to every person in the United States. The Constitution does not say citizen. That's been that's the letter of the constitutional provision. That's been the interpretation of our Supreme Court throughout, and that has not changed. The Alien Enemies Act, which is the first case that went in this administration to the Supreme Court. Alien enemies, these are people the government decides are not only aliens, but they're enemies. This Supreme Court was keen to point out in the very first few months of this administration that the Constitution applies to all persons. And that if you want to hold someone, you want to deport them, you have to give them the judicial, you have to give them due process and judicial review. That the Supreme Court has been keen to point out throughout, and I must say that's been keen to point out even in this administration very robustly. So the Constitution survives, that it applies to all persons. It makes no distinction between classes of people.
Any other questions from members of the committee? Senator Holmstrom.
Back on the process of detainers in counties or jails or utilizing them, Keith Ellison, Attorney General Keith Ellison, has stated that these organizations, whether it be the county or local authorities, risk civil liability if they hold people based solely on federal immigration detainers. How is that affected if they choose to enter into a 287G agreement?
Mr. Chishti.
Yeah, I think that's a good question. We firmly believe that the detainer stuff is not affected by 287G. 287G, many of you members know, is basically a provision of the law that exists only since 1996 and was never enforced till 2002. It basically deputizes states and local officers to do some immigration enforcement function. But they're to be trained and they're to be supervised. It's not anyone. So they're a designated official. The principle about detainer does not override the 287G. Just because you have a 287G agreement does not give you the right to hold someone beyond what you would normally hold them under your state laws and guidelines. So I think the answer to that is quite well settled. That if you hold someone beyond what you normally would hold them, you are subject to potential civil litigation. And as I pointed out, very successfully, a bunch of immigrants were able to do that even under this administration in a recent case in Long Island, which led to, I think, multi-million-dollar settlement.
Senator Holmstrom.
Thank you, Chair. To follow up on that, so a lot of these cases in Minnesota hinge on a lack of law in Minnesota as being the reason that they prevail in court. At least that's my understanding. Is that correct, that because state law fails to properly address this, this problem exists?
Mr. Chishti.
Yeah, thank you. I mean, I don't think it's the absence of state law. I mean, states don't have any jurisdiction to either enact or enforce immigration laws. I mean, they're just enacting laws which are relevant to the public safety of the state. I think I'm not in the state. I'm not a state expert. I just follow news. Is that I think the conversation has been, at least the allegation of the federal government has been, that the states or the localities are not fully or more robustly cooperating with the federal government. And to me, parsing that just means that they're not cooperating with us in the arrest or release of any person that we're asking them to release, that they are deciding who to release and who not to. And I think that's where the dispute is. And to just restate what I said earlier, that decision about what classes of criminals you will release to federal government or no is truly determined by each state and each locality. And that's sort of where the distinction between variations of sanctuary jurisdiction lies. And I think that's sort of what probably the debate is within the state of Minnesota and the DHS today.
I don't see any further questions from members of the committee. Mr. Chishti, thank you so much for your generosity this morning, the time you shared and your expertise you shared with us today. It's been very helpful.
Thank you so much for having me, and thanks for all the great work you folks do.
Thank you. Have a great day.
Thank you.
All right, members, the next stop here is the consideration of a number of bills. We are not going to be taking any formal action at the end of our consideration of each bill. There may be some author's amendments relating to them, but it's the intention of the chair to lay all of them over when we're done with our consideration of each bill, and a determination of what will be the next steps for each bill will be made at a different date. We're going to start now with Senate File 3628. Senator Champion has this file, and there is another bill, chief authored by Senator Fateh as well. I don't have the Senate file number. Senator Champion's. And Senator Fateh has the Senate File 3629. They are identical bills. They intend to co-present. So we welcome both Senator Fateh and Senator Champion to the testifier table. Who's going to start?
I'll start.
Senator Fateh, to your bill.
Thank you, Mr. Chair and members of the committee. I'm honored to partner with my good friend President Champion on this legislation as the co-chief author. And so I want to speak to a little bit about what we have been seeing, and then pass it off to President Champion in regards to the language and things like that. And so we've seen the largest ICE operation in our nation's history right here in Minnesota. We've seen an investment of over $170 billion in immigration enforcement federally. We've seen over 3,000 agents deployed throughout different communities, different neighborhoods throughout the state of Minnesota, especially within the Twin Cities metro area and also greater Minnesota. In the area that I represent in Southside Minneapolis, we've seen ICE agents going throughout the neighborhoods and at many times violating the constitutional rights of our residents. We've seen instances in which people with all citizenship statuses, including United States citizens, folks that were born here, that have been questioned, that have been detained, and we've seen two of our community members that were killed, both Renee Good and Alex Preddy, both of which happened in District 62. We've seen instances in which our businesses have been struggling, our small businesses. We've heard stories of ICE agents going into restaurants, for example, in the south side of Minneapolis, entering, closing the door, locking the doors behind them, and demanding the paperwork of workers, the owners, folks that were frequenting the establishment. We know that's not supposed to be happening. We've heard stories from young people that they've been questioned or detained or picked up on campus. We've seen instances in which, especially picked up randomly in the middle of the night, we've heard stories in which students that were picked up, that their families didn't know where they are, their lawyers were unable to locate them and figure out, the university presidents and the schools were unable to know their whereabouts. And so we've also heard stories of students hearing from them students, especially that were born here in America, saying that they're afraid to walk around without carrying their passports. And in 2026, that shouldn't be happening. We've seen operations going on in schools as well, including instances in which students, staff have been tear gassed, pepper sprayed. That should not be happening, especially to our young people, our students. And so right now, there is no legal path for individuals who have had their constitutional rights violated, in which federal immigration officers can be held accountable for those violations or sued for those violations. We have yet to see an end to the occupation that we've been witnessing, but even when it concludes, we know that that's not enough, that there has to be accountability for the injustices that we have witnessed. And so with that, I want to pass it off to President Champion.
Senator Champion.
Thank you so much, Mr. Chair. Thank you to the committee for listening to this bill this morning. And I am pleased to be joined by Senator Fateh as we seek to provide a remedy for Minnesotans. Mr. Chair, I'll be brief because I know that you have a number of different bills to hear today, but I think it's important to put some context around why this bill is important. Most people have heard about the federal law known as Section 1983 that allows people to sue local and state officials if they violate the Constitution as a means of enforcing already existing civil rights. There is, however, no equivalent federal statutory law that allows people to sue federal officials. As such, federal immigration enforcement officers can't be sued for violations of constitutional rights. Some have also heard about the Bivens Act, whereas in the past allowed for a cause of action to be brought, but although the Supreme Court has not expressly overruled Bivens, it has declined to recognize a Bivens action for nearly 50 years. As a result, people whose constitutional rights were violated by federal officials now, in many instances, are left without a legal remedy. This bill remedies the lack of a federal Section 1983 and the erosion of Bivens action by creating a right of action and giving individuals the right to a cause of action against federal officials. And namely, when you look at Senate File number 3628, which is also identical to Senate File 3629, the first section is the cause of action. What it does is that it establishes a civil cause of action against any person who, under the color of any statute, ordinance, regulation, custom, or usage of the United States or any state, violates another person's rights under the United States Constitution or the Minnesota Constitution. The court may award to a prevailing party damages, including injunctive relief and reasonable attorney fees and costs, and the statute of limitations for action under this section is 6 years. Subdivision 2 prohibits a state or local law enforcement agency from entering into a partnership with a federal agency unless the federal agency agrees in writing that the agency will abide by the United States Constitution and the Minnesota Constitution, and the agency's officers may be held liable for any violations of the federal or state constitution. Mr. Chair, this is to, I don't want to say react to, but provide a tool for Minnesotans, because this is our state where I've been out in the streets there. I've seen the constitutional rights violated of constitutional observers. We've seen people who are just looking to, record what is happening, and the list goes on and on for their rights to be violated. You'll hear from some of those today, but that's the context and why this bill is important, because it gives Minnesotans a tool to take a federal official to court if their constitutional rights have been violated, whether that's the First Amendment, Fourth Amendment, Sixth Amendment, Seventh Amendment, 10th Amendment, you name it. And they still have to prove it. And so, but here's a tool that allows them to do so. So with that being said, Mr. Chair, We do have our first testifier, if it's okay with the court. Excuse me, with you, Mr. Chair, I'm so used to being in court. I said, is it okay with the court, right? Right? Is Megan Forbes, she's with...
You can call me Your Honor if you really insist.
Your Honor, Your Honor.
But I've made the mistake plenty of times like you have, Senator.
Megan Forbes is with the Institute for Justice, and she's here to give some brief context as well.
So what we're going to do here, Senators, is we have 5 people have been identified as testifiers on behalf of this bill. And I think we told you this ahead of time. We're going to have to limit the time of the testimony. So we're asking members to focus on 90 seconds to 2 minutes each for testifiers so we have time to fit everyone in. So welcome, Ms. Forbes. If you go ahead and identify yourself and your affiliation for the record and present us with your testimony.
Thank you, Mr. Chair and members of the committee. My name is Megan Forbes, and I'm Senior Legislative Counsel at the Institute for Justice. We're a nonprofit public interest law firm that works to protect civil liberties, and we appreciate the opportunity to testify in support of this bill. This bill responds to a serious problem. There are not meaningful legal remedies available for constitutional violations by federal officials in state or federal courts. Right now, if a federal official goes into your house without a warrant, trespasses on your land, takes away a legal firearm, retaliates against you for exercising your right to free speech or freedom of religion, beats you, or even kills you, there's not much you can do to protect your rights. You cannot sue them in most state courts. You cannot sue them in federal courts, and that's wrong. A right without a remedy is not much of a right at all. This bill restores a legal mechanism that was once available at common law and under federal precedent. It's an important fix that brings much needed reform. 5 states already have state causes of action authorizing suits for damages for violations of the Constitution, and some of these laws have been on the books for decades. This bill creates accountability, which builds trust. Trust is a critical part of law enforcement, and when government agents think that they can act with impunity and appear to do so, it breaks down that trust and makes law enforcement interactions less safe, more confrontational, and less effective. Lastly, I'd like to note that this bill opens the courthouse door, but judge-made immunity doctrines would still make these cases difficult. There's also bipartisan legislation this session that would complement this bill by waiving those immunity defenses to give civil litigants a fair chance to prove their case, and that's another needed reform. So to wrap things up, we encourage the committee to support this bill and to stand with the Constitution and the state's right to enforce it. Thank you.
Thank you, Ms. Forbes. Appreciate your testimony. So what I'm going to do is identify the folks who are going to be next, and then so if Ryan Eklund, or is Ryan also from the Institute for Justice, as I understand? Okay, are you coming forward? So why don't you come on up and take Ms. Forbes' place at the testifier table? And John, is it Baylor or Bowler? Baylor? Or someone else from the ACLU scheduled to testify will be next. All right, thank you. Go ahead and identify yourself for the record.
Yes, thank you, Mr. Chair and members of the committee. My name is Ryan Eklund. I'm a resident, lifelong resident of Minnesota, current resident of Woodbury, Minnesota. I'll be very brief in terms of my interaction with ICE. On January the 12th, I'd finished taking my 7th grader to school, was stopping by the local grocery store when I saw an ICE vehicle essentially patrolling through the lanes in the parking lot. This was the first circumstance where I saw an ICE vehicle sort of in the flesh in my community after hearing for a number of days that they were present in my community and actively pursuing actions against people that they felt were there illegally. At that point, I felt a strong sense of responsibility as a citizen, as a member of my community, to hold the individuals who are instilling fear and anxiety in our communities accountable for their actions. So while trying to keep myself as safe as possible, stayed in my vehicle and grabbed my cell phone and started recording them from a good safe distance. At approximately 90 seconds to 2 minutes later, they parked in an adjacent parking lot. I parked near them, and one of the ICE agents got out of their vehicle, came up to my window, took a photograph of me, and then immediately got back into their vehicle. At which point I continued to follow them, recording all the while, as they then went up the street approximately a mile away and turned into my neighborhood, onto my street, and into my cul-de-sac. They essentially led me to my home in a clear effort to show me that they know who I am, they know where I live, and that I should not continue to hold them accountable. I continued to do so. Continued to follow them, at which point, after following them for a total of about 8 minutes, I was then boxed in by 2 different ICE vehicles. I was forcibly removed from my vehicle. One of the ICE agents opened the car door. Another one crawled into the back seat and put his arm around my neck, used his other hand to remove my seatbelt, at which point 4 other ICE agents removed me from my vehicle, put me to the ground, put me in handcuffs, and put me to an unmarked white van, and then led me to the Whipple Federal Building. I say all of that to say this. The room that I was in for the 10 hours that I was in the Whipple Federal Building with leg irons on my legs, the room that I was in was then filled throughout the day with a total of 8 U.S. citizens, all of whom were utilizing their constitutionally protected rights to record the activities of ICE agents. At no point in time was I impeding their investigation. At no point in time was I causing alarm or awareness to their presence. I wasn't honking my horn or flashing my lights. I was simply recording them from inside my vehicle. This kind of precedent is a dangerous one, and I would encourage the members of the committee to strongly encourage what this bill does, which is simply provide citizens a mechanism by which they can protect and hold those accountable for violation of their rights. What I did was done under the guise of accountability, and I still believe that holding the individuals accountable for their actions is what I did and what I will continue to do.
Thank you for your testimony today. So you can go ahead and depart the testifier table. We'll invite John, is it Baylor? I want to get it. Beeler. Option 3. Sorry, I also want to remind members of the audience the decorum here. There is to be no display of expression, support, or opposition to any of the testimony that's here today. If it happens again, any individuals that do that will be removed from this hearing room. We're going to have proper decorum and respect for all views that come before this committee. Mr. Beeler. Next will be Jaylani Hussein.
Thank you, Chair Latz, members of the committee. My name is John Beeler. I'm the Policy Counsel with the ACLU of Minnesota. We're testifying today in support of SF 3628. For the last few months, Minnesotans have watched as their neighbors have been gassed, pepper sprayed, dragged from their cars, detained without cause for hours, sometimes days, along with 2 extrajudicial killings. There's virtually no pathway for private individuals to sue federal officers for violations of the U.S. Constitution. While 42 U.S.C. 1983 provides a federal remedy for constitutional violations by state and local government officials, there is no comparable federal statutory remedy for such violations by federal government officials. State legislatures can and must fix this gap by creating their own laws, sometimes known as Converse 1983 laws, that allow individuals to sue federal officers for violating the U.S. Constitution. The bill does apply uniformly, though, provides remedies under the federal and state constitutions and against federal, state, and local officials. That parity, that equal treatment of government officers provides this bill a necessary constitutional grounding. Currently, people can bring claims against state and local officials for violations of constitutional rights, the 1983 statute, and against federal officers for state tort claims under the Federal Tort Claims Act, but crucially not for violations of their constitutional rights. In 1971, the Supreme Court held that the U.S. Constitution itself created a right to sue federal officers. That's the Bivens case that Senator Champion discussed, but subsequent case law following that decision has whittled away that right, creating a legal accountability gap for federal officers that is especially alarming in light of their current behavior. We support this bill because it fills that crucial gap. remedies for violations of constitutional rights by federal actors, but also because it provides an independent state-level remedy for violations of constitutional rights by state and local officials, separate from that federal 1983 statute. We urge this committee's support for SF 3628. Thank you.
Thank you, Mr. Beeler. Appreciate your testimony.
Mr.
Hussein, Senator Champion.
Jelani Hussein is not here, and it's my understanding Suleiman.
Yeah, Suleiman, who is the deputy director, he's here in replacement of Jelani, who couldn't make it today.
That's fine. He's welcome to come forward. And then after that will be Christopher Marty.
Thank you, Mr. Chair.
Thank you, Senator. Good morning. If you go ahead and identify your full name for the record and your affiliation.
Good morning, Mr. Chair and members. My name is Suleiman Adan, Suleiman, last name Adan, Adan, and I'm the Deputy Executive Director at the Council on American Islamic Relations here in Minnesota, and I'm here in support of Senate File 3628. We here in Minnesota often are the place people come to when they believe their rights have been violated and they don't know what to do next. As leaders that do ongoing Know Your Rights training, we have folks that have come to us and said, you've told us what our rights are. However, when we flex our rights, those don't seem to matter. Every week we sit with Minnesotans trying to understand what protection actually means in practice. In real life, when systems fail, when authority is exercised, and when people are trying to figure out what recourse they even have. You know, the Constitution, as someone who immigrated to this country, I took an oath when I turned 18 to what that flag represents and what the Constitution promises. Those words only matter if people can actually use them. And this bill is about making sure constitutional rights are enforceable here in Minnesota. And you'll hear that legal pathways already exist. And yes, federal court is an option. But from where we sit here at Minnesota, helping real families, that path is often too expensive and too far out of reach, and not within the reality of most Minnesotans. Most folks cannot navigate federal litigation, and this bill gives people a state-level path when their rights under our Constitution are violated. And this is not a duplication or making the system harder. It's about access. And it's not about punishing officers. At Minnesota, we've worked with officers when the Muslim community or other faith communities have been attacked. It's about setting clear constitutional guardrails so everyone knows the standard. And we trust that you all will make the right decision, because when trust erodes, public safety erodes. And on behalf of Minnesota, we urge your support. Thank you.
Thank you for your testimony, Mr. Adan. Was it Adan?
Adan.
Adan. All right. I'm not doing too well with names here today. Thank you for your testimony. Christopher Marty.
Hi there. Hi there. I'm Chris Marty. I am just a citizen. I'd just like to talk about in support of the bill. On January 11th, right outside my house, there was some honking, and went to the scene and tried to see what was going on. There was a number of ICE agents there. I showed up with a drum and proceeded to just witness what was going on. They started harassing some of the citizens, backed out of the alley really fast, ran into a neighbor's car, proceeded to pepper ball and pepper spray and a couple old ladies, and then they geared up to go into my neighbor's house, Gibson in Brooklyn Center, and we asked them for a warrant. They didn't present a judicial warrant at all, and they broke down his door in January without a warrant, pointed guns at his kids, and took him away. He was later released. All charges were dropped. So then on the 14th, I showed up again because I heard of another shooting where, some people were saying that they had attacked a pregnant woman. I said that the guy had a gun and there was a shovel. All that turned out to be not true later, and it was just made up by them. But they proceeded to blanket the neighborhood with tear gas and pepper spray and totally deny people their right to peacefully protest. And finally, on the 24th, I went to another hearing of a shooting on Nicollet, not knowing what was going on, and I showed up with a drum and peacefully protested, didn't interfere with anything that happened, and they showed up with an armored vehicle and just caked me in pepper spray, tear gas, flashbangs, you know, completely unreasonable response to people asserting their constitutional rights. And I think that the real problem here is that there is no checks and balances. We're all taught in civics class that this should check that and there should be a balance. So I'm very much in support of some sort of action for civilians to do something when stuff like this happens. Thank you.
Thank you for your testimony, Mr. Marty.
And Mr. Chair.
Senator Champion. Mr. Marty, you can go ahead and return.
We do have one more person, Ed Higgins, but he did submit his testimony. And so if you had 90 seconds, great. If not, his testimony is there, but he is present with us as well.
We have distributed his written testimony. If he wants to take 90 seconds to tell us something in person, that's just fine right now.
Thank you, Mr. Chair. And y'all know that it's 90 seconds or less.
That might be hard. I'm from Boston, Massachusetts, but I'll try. My name is Ed Higgins. Chairman and members of the committee, my name is Ed Higgins, and I'm a United States Marine Corps veteran, business owner and marketing director, and constitutional observer living with my wife and 2 fur babies in the great city of Columbia Heights, Minnesota. I come from a long line of system builders and public servants in this country. I understand how government is supposed to function. What I've witnessed since the military occupation by this administration's cospatriot forces is not a system. It is a lawless shit show built on faulty intelligence,
I'm going to interrupt
vibes,
you right
and
now,
personal
Mr.
vendettas.
Higgins. I'm going to interrupt.
I will censor myself. I apologize.
First of all, there is a decorum rule in this committee hearing, as there is in the Senate generally. Everyone is expected to follow it. Secondly, I'm going to remind you, we do have your written testimony. If you go past 90 seconds or 2 minutes at the longest, I am going to cut you off. No disrespect meant, but you're kind of getting in as an added testifier here today as it is. So we appreciate your being here and sharing what you have to share. But just so you understand what we're
yes, so ICE agents attempted to murder me twice. One morning at Liam Ramos's house, they brake checked me, they hit me with their car, backed over me, they broke my phone. That's the reason why I wasn't at his house that morning or that afternoon when he was kidnapped and his father was kidnapped. They also attempted to murder me on February 5th. They tried to box me in. I maneuvered around them and was driving by, and they turned their cars so that they would scrape my car, and then proceeded to to follow me on a 4-minute chase, which is recorded on 911 call, to the police station where they boxed me in and were trying to break my windows with guns. The only thing that saved my life was Scott Mueller from BCA happened to be parked right next to me for a meeting that wasn't even related to anything. He got out of his car and he de-escalated the whole thing. This is just one small moment that I have seen in Columbia Heights 15 hours a day for almost 6 weeks terrorizing our community. Our constitutional rights have been trampled all over our city, and I've seen many more throughout the state. We need to support this bill because there needs to be some kind of accountability. Without accountability, the law is meaningless. Thank you.
Thank you so much for your testimony here today. Senator Champion, I understand there's an author's amendment, an A1 amendment you'd like to offer?
Yes. There's the A1 author's amendment.
Senator Umover Benton will move adoption of the A1 amendment. Is it in our packets, members? Okay, it's in your packets. Would you like to tell us what the amendment does, please, Senator Champion? Or Senator Fatah?
It just deletes, in fact, this was a technical amendment that was given to us. Maybe council could do a better job than I.
Ms. Primo.
Mr. Chair and members, yes, looking at the A1, this just changes the language so it's in line with how we normally draft. Effective dates for causes of action. Yes.
All right. Do all members have a copy in their packets?
It's up there.
Mr. Chairman.
Senator Lemon.
Thank you, Mr. Chairman. Earlier in the meeting, you had said there would be no votes on particular bills.
I did say there might be some
author's amendments. Is this just to refine the idea for a later date?
Senator Limmer, I did mention earlier that there may be some authors' amendments to some of the bills as well. There'll be no final action taken on the underlying bill.
Thank you.
Yes. Senator Kroon, do you have a copy? All right. Are there any questions for Senator Champion on the A1 amendment? Any discussion? Senator Hoover Benton moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Any further discussion before we lay Senate File 3628 over? All right.
Sorry.
Senator Holmstrom.
Yeah, I have a question for Senator Fattah. Thank you, Chair.
Go ahead. Okay. What's your question? Go ahead.
The Sheriff's Association has correctly asserted that this bill will likely destroy all federal and state local partnerships. These partnerships are crucial in prosecuting fraud like Feeding Our Future, and obviously will be necessary in prosecuting the $9 billion in fraud moving forward. So I'll just plainly ask you, was it your intent to make these investigations harder, or was the goal just to undermine fraud investigations explicitly into the future?
Senator Fattah.
Thank you, Mr. Chair, and thank you, Mr. Holmstrom, or Senator, I apologize, for that question. And the answer is no. But what we have seen is that at least 14 federal prosecutors have resigned, including the lead prosecutor for Feeding Our Future. So this operation has not been about fraud. It's been made far worse by jeopardizing the current cases that we've seen, and that's a direct result about the actions from our federal government. And if anyone else wants to jump in, I'll allow them to.
Senator Champion.
And just briefly, again, there was no intent at all in order to undermine any investigation or nothing of the sort. In fact, if you look at the second division, the subdivision 2, really what we're saying is that if a federal agency or others are going to be here and wants to partner with our local agencies, that they abide by the Constitution, the U.S. Constitution, and the Minnesota Constitution, and that's really what they should be doing anyway. But we just explicitly make certain that that is the information that they would have to abide by in subdivision 2.
Any further discussion or questions from members of the committee? Senator Holmstrom.
Follow up to that, are you saying that it's an unintended consequence that it shuts down all the fraud investigations? Because to this point, the only effective fraud investigations, or at least wholesale, have been from the federal agencies, which require help from local authorities.
Senator Holmstrom, if complying with the Constitution shuts down an investigation, then the investigation ought to be shut down. Any further discussion from members of the committee? Not seeing anything further. Senator Kroon, I'm sorry.
Thank you, Mr. Chair. The question is for the authors. We have in our packets a letter from the Minnesota Sheriff's Association that's where Senator Holmstrom's quote just came from. And I'm just wondering if in drafting or creating this bill, that if you've worked with the Sheriff's Association or any other law enforcement agencies.
Senator Champion.
Thank you, Mr. Chair. Thank you for the questions, Senator Kroon. We are open to working with anyone, but we did not work with them specifically on this particular bill, but we did take their thoughts, or what we would believe their thoughts, into consideration. For an example, there was a concern that they expressed that this is duplicative of Section 1983 and will lead to costly and unnecessary litigation. That's incorrect. Because the federal civil rights statute, Section 1983, only applies to suing state and local officials for federal constitutional violations. There is no mechanism right now for federal officials to be sued under 1983. There was another concern that was expressed by them around Bivens, and saying that the U.S. Supreme Court precedent is a viable remedy for federal abuse cases, so that this state-based cause of action is redundant. As I mentioned earlier, and I'm not certain if you're in the room, but the Bivens decision has been dramatically narrowed over the years, making it almost impossible to hold federal officials accountable for constitutional violations. In fact, I mentioned that it's been 50 years, 50. And no action of the Bivens Act for over 50 years. So we don't believe there is a problem there. there was one additional concern that was stated around that state and local task forces wouldn't be able to function. We believe that they would be able to function, and clearly what we are doing here is not to subvert or deter or create a problem for individuals to enter into agreements. We just want the individuals to agree that they're going to function by the Constitution, the U.S. Constitution, and the Minnesota Constitution.
Senator Fontaine.
Yeah, thank you. And I just want to add a little bit to that context as well. And so this is also a piece of legislation that is also, we also see in the STAR Act, which is legislation that was also drafted 2 years ago. And a coalition of 50-plus organizations have been working together on that. And so within the STAR Act, there's multiple different sections. And within those sections, the sheriffs, as well as law enforcement from other jurisdictions, there's been multiple meetings on it as well. And so while there hasn't been specifically for this bill, within the STAR Act, there has been conversations with law enforcement.
Senator Kroon, follow-up.
Thank you, Mr. Chair. Well, we're creating a new, under your bill, would be creating a new cause of action that the Sheriff's Association says would destroy longstanding law enforcement partnerships that have taken apart major criminal enterprises and caused the capture of some of the most dangerous criminals in Minnesota. It goes on further to say it will devastate federal and state partnerships designed to vigorously pursue social services fraud. Now, you may disagree with what's in the sheriff's letter, but I think what this highlights is that before we go and embark on any major change, creating a new cause of action, where the Sheriff's Association has strong words like that, I think we need to have all stakeholders at the table, take everything into consideration to make sure that we aren't blowing up all sorts of partnerships that we have with the federal government, because there are many that do many, many good things. And so you have to worry about unintended consequences, if that's what you claim the devastation of the federal and state partnerships designed to vigorously pursue social services fraud is. If you claim that's an unintended consequence, we need to get to the bottom of that. We need to have everybody at the table and make sure that we're doing this in the right way. So from my perspective, this isn't even close to being ready to do the kind of work that we typically do here in the Judiciary Committee to make sure that we have all stakeholders at the table and that and make sure that we're doing this in the right way. So from my perspective, this isn't even close to being ready to do the kind of work that we typically do here in the Judiciary Committee to make sure that we have all stakeholders at the table and that